Welcome, everyone, to the Competition Bureau's public information session on the recent amendments to the Competition Act. My name is Anthony Giroche, and I am Deputy Commissioner responsible for the Bureau's Competition Promotion Branch. And today, I'll be joined by my colleague, Majid Sharania, who is our Director of Compliance.
Hi, everyone. I'm glad to be here today, and I look forward to our discussion.
So before we begin, I would like to acknowledge that we are speaking to you live from our offices in Gatineau, located on the traditional unceded territory of the Algonquin Anishinaabe people, and we are grateful to be speaking to you from these lands. So the goal of today's session is simple. We want to provide an overview of the most important changes to the law, talk about our next steps, and try and answer some of your questions. So as most people should be aware, this session is being recorded, and we do intend on publishing a recording of this session, as well as tomorrow's session in French on our website in due course. Donc, un petit rappel que cette présentation sera faite entièrement en français demain à cette même heure. With that said, the session is not intended to provide legal advice. The Bureau's role is to administer and enforce the Competition Act, but the final interpretation of the Act rests solely with the Competition Tribunal and the courts. So there's been a good amount of interest in our information session today. We had about 175 people register for the session. And it really is a bit of a diverse crowd, including experienced competition lawyers. We have in-house officials from companies large and small. We have members of the general public, public servants, academics, and officials from think tanks. And there really is a wide range of knowledge regarding both the Bureau and competition law. So what we're going to try and do is to present our content at a high level to try and accommodate everyone's needs and level of knowledge. So we are also going to do our very best to make the session accessible to all. And to that end, I'd like to introduce Tanya Adler, who will be providing interpretation in sign language today. And you can also view captions by clicking on the three small dots at the top of your screen and selecting Turn on Live Captions. So we have about an hour for this session, and there are a number of amendments that we'd like to discuss and leave some room for questions. So we've scheduled the session as follows. The first half will be devoted to presenting the changes. This should run about 25 minutes, give or take, and the second half is going to be reserved for questions and answers. I'd like to thank those of you who've submitted questions in advance. We received quite a few. Given the volume of the questions we received, we won't be able to answer all of the questions today. There truly were a lot of excellent, well thought out questions. Some were very specific to certain facts or particular industries or sectors. We've taken a careful look at them all and tried to prioritize the ones that came up the most frequently. So for the questions that we are not going to be addressing today, I can tell you that either someone from the Bureau may contact you to discuss directly, or we're hopeful that the response may be covered in forthcoming guidance that we're going to talk about a little later on. So now I will hand it over to you, Majid.
Thanks, Anthony. So to start, I'd like to introduce the Competition Bureau. We're an independent law enforcement agency that protects and promotes competition for the benefit of Canadian consumers and businesses. We're headed by the Commissioner of Competition, who's responsible for the administration and enforcement of the Competition Act and other federal laws. So in addition to the Bureau, there are three other important parties in Canadian competition law that I'd like to mention. First, as Anthony mentioned before, there's the Competition Tribunal, and the courts, which adjudicate matters under the Act. There's also the Department of Innovation, Science and Economic Development Canada, and they develop and coordinate government policies, laws, regulations respecting competition, including the amendments that we're discussing today. And also, there's the Parliament of Canada, and Parliament must approve all legislation in order for it to become law, including the legislation that led to these amendments. So now let me give just a bit of an overview about the Competition Act. So the Act is a piece of federal legislation, and it's the nation's only competition law statute. The Act contains both criminal and civil provisions, and they're aimed at preventing and prohibiting anti-competitive and deceptive practices in the marketplace. Now, let's talk a little bit about the amendment process to date. So, a little bit of an overview about how we got here. The government first mentioned changes to Canada's competition law in April of this year in Budget 2022. The amendments that we're discussing today were then introduced in the Budget Implementation Act, which received royal assent on June 23rd of this year. And the government has signaled that there will be broad consultations on further competition law reform. So now let me hand it over to Anthony, who will talk about the changes themselves.
All right. So let's talk about the changes. So our presentation will largely follow the format of our guide to the 2022 amendments to the Competition Act. And we're going to make sure that we provide a link to that guide in the chat. We published our guide on our website in June, and it provides an overview of the most important changes to the law that we're going to talk about today. These changes are in the following areas: fines and penalties, wage fixing and no poaching, drip pricing, competitive impact factors, abuse of dominance and anti-competitive acts, private access to the tribunal, evidence gathering powers, and lastly, merger review notification requirements. So let's start with fines and administrative monetary penalties, which I will refer to as AMPs. For those of you who aren't aware, an AMP is a monetary penalty that may be imposed by civil courts for deceptive marketing and abuse of dominance. Fines and AMPs play an important role. They ensure compliance with the Competition Act by providing a financial incentive for businesses to comply with the law. If we look at cartel fines in particular, so the starting point is, what is a cartel? A cartel is a criminal agreement between competitors to fix prices, restrict supply, or allocate markets. An example of a cartel could be competitors who agree on the price of gasoline in a local market. Now, the previous fine maximum of $25 million for criminal agreements between competitors was removed, and fine amounts will now be at the discretion of the courts. This change, along with other criminal provisions, will not come into force until June 23, 2023. And this is to provide businesses with a sufficient amount of time to become compliant or adjust their business practices. So when we look at the effect of this amendment, it is really that the Act's pre-existing limit on fines for cartels was removed, and the maximum is now at the discretion of the court. If we shift gears and talk about deceptive marketing practices, AMPs. So deceptive marketing practices include advertising or promoting a product or a business interest to the public in a false or misleading way. The provisions also prohibit a business from making a claim about a product's performance. or a product's effectiveness or length of life that is not based on adequate and proper testing. There are two categories of deceptive marketing AMPs, those for individuals and those for corporations. And the amendments increase the possible maximum for both. So let's start with individuals. The previous AMP maximum was $750,000 for a first violation. The new maximum penalty is the greater of $750,000 and 3 times the value of the benefit derived from the deceptive marketing conduct, if that amount can be reasonably determined. Now, for corporations, the previous AMP maximum was $10 million for a first violation. The new maximum penalty is the greater of $10 million and 3 times the value of the benefit derived from the deceptive marketing conduct. Or if that amount cannot be reasonably determined, 3% of the corporation's annual worldwide gross revenues. The amendment effect here is that the maximum AMPs for deceptive marketing for both individuals and corporations have increased. We'll now move to discussing AMPs for abuse of dominance. Now, being big is not a problem under the Competition Act. The Act only becomes engaged when a dominant firm takes advantage of its privileged position as a market leader to act in ways that harm competition. Abuse of dominance occurs when one or more dominant businesses engages in an activity that harms competition. So, what does this mean in practice? Well, an example could be a dominant firm in a market for widget manufacturing that uses long-term or exclusive contracts to stop customers from changing suppliers, forcing their rivals to leave the market. The previous maximum AMP was $10 million for a first violation. Then the amendment makes it so that the maximum penalty now is the greater of $10 million and 3 times the value of the benefit derived from the anti-competitive practice. If this amount cannot be reasonably determined, then 3% of annual worldwide gross revenues will be used instead. So the effect of this amendment is really the maximum AMP for abuse of dominance has been increased. I will now turn to you, Majid, for wage fixing and no poaching.
Great. Thanks, Anthony. So the amendments have added a new criminal conspiracy provision, collusion, to the Competition Act. And its purpose is to protect competition in labor markets by protecting workers from employer agreements that fix wages, like denying salary increases, for instance, or restrict employee movement from one company to another. So an example of conduct that might be considered wage fixing would be a group of unaffiliated retailers agreeing on salaries for their employees. So specifically, the amendment will make it an offense for unaffiliated employers to do 2 things. First, to agree to fix, maintain, decrease, or control wages or other terms of employment, and we would know that or call that a wage fixing agreement. Second, to refrain from hiring or trying to hire one another's employees, and we would call that a no poaching agreement. So the penalties for these types of conduct are imprisonment for up to 14 years, or a fine to be set at the discretion of the court, or both. Now, this section will not come into force until June 23rd, 2023, so next year. And that's to provide businesses with sufficient time to adjust their business practices and become compliant. So to summarize the effect of this amendment, wage fixing and no poaching agreements will be illegal under the criminal conspiracy provisions of the Competition Act. Now, we received a few questions on guidance regarding this change to the law, and we'll come back to them during the Q&A session. Now, I'll turn to changes in the deceptive marketing provisions in the Act, namely drip pricing. So, what is drip pricing? Drip pricing occurs when a product or a service is offered at a certain price, but a consumer can never actually attain that price because of additional mandatory charges or fees. The term drip pricing is used because the additional costs are often dripped one at a time onto the initial price offered. And while each dripped fee might be relatively small, they can add up quickly. So let's consider an example. An online ticket vendor offers low prices for concert tickets via its app. However, additional mandatory fees are added later in the purchasing process, and the real price of each ticket is greater than the original advertised price. So this conduct would be considered drip pricing. Now, prior to the amendments, we successfully took on a number of drip pricing cases under the existing false or misleading advertising provisions in the Act. The first set of cases were in the car rental industry. And in those cases, we reached settlements with a number of major car rental companies. And they had to pay penalties and they had to change their marketing practices. Now, more recently, we've taken similar action against online sporting and entertainment ticket vendors. Now, the recent amendments explicitly add drip pricing to both the civil and the criminal deceptive marketing provisions of the Competition Act. Now, I should mention that these provisions do not apply to charges or fees that are entirely government imposed, such as, for instance, sales taxes. So, bottom line, drip pricing has been added to both the civil and criminal false or misleading advertising provisions of the Act. So now I'll hand it back to Anthony to talk about competitive impact factors and anti-competitive acts.
Great. So the Competition Act contains a non-exhaustive list of factors that may be considered when assessing the anti-competitive effects of mergers, abuse of dominance, and competitor collaborations. Let's give an example. When we're conducting a merger review at the Bureau, we will consider whether one or more barriers to entry are sufficient to impede entry by a new competitor. The amendments expand the list of factors. While some of the new factors may arise in digital economy cases, they are also applicable more broadly as well. Before reviewing the amendments themselves, I'll talk briefly about the meaning of anti-competitive acts. Higher prices, lower quality, reduced service or innovation, diminished output, and fewer choices are examples of anti-competitive effects. The types of anti-competitive effects that can arise are largely determined by the nature of the action at hand. If we look at mergers and competitor collaborations, the added factors include network effects as another example of a barrier to entry in a market, the possible entrenchment of leading incumbents' market position, and the effects on both price and non-price-based forms of competition, such as quality, choice, or consumer privacy. For abuse of dominance, the amendments expanded the list of factors as well. The list now includes network effects and price and non-price competition effects, as I just mentioned. The list also includes the nature and extent of change and innovation in the relevant market, and any other factor that is relevant to competition in the market that is or would be affected by the practice. So the bottom line with these amendments is that the list of factors to be considered when assessing the competitive impact of mergers, business practices, and competitor collaborations are expanded. Let's now turn to Section 78 of the Competition Act and what we term anti-competitive acts. Now, recall that the abuse of dominant position occurs when a dominant firm or a dominant group of firms engages in a practice of anti-competitive acts that harm competition. Simply being a dominant firm or even a monopoly is not offside the act in and of itself. The amendments adjust the anti-competitive acts listed in the Act in two ways. First, anti-competitive act is now a defined term and means any act intended to have a predatory, exclusionary, or disciplinary negative effect on a competitor or to have an adverse effect on competition. Second, a new example of an anti-competitive act has been added to the list. A selective or discriminatory response by a dominant player to make it more difficult for a competitor to enter a market or grow, or to remove a competitor from a market. So looking at the effect of the amendments here, for abuse of dominance, the amendments clarify the definition of any competitive act and expand the list of examples of business practices that may be considered under the abuse of dominance provision. I'll now hand it back to Majid to take us through the amendments related to private access and mergers.
Great, thanks, Anthony. So let's first talk about private access. What is private access? Private parties, such as your business or your client's business, may apply to the competition tribunal if they're directly affected by the conduct of another party. Prior to the amendments, private access was only available for certain types of business practices: refusal to deal, price maintenance, exclusive dealing, tied selling, and market restriction. So the amendments extend private access to the competition tribunal to abuse of dominance cases. Now, all persons seeking private access must obtain leave from the competition tribunal under the existing legal standard for leave. So bottom line for private access is that now in abuse of dominance cases, that right is available. I'll shift gears now to talk about pre-merger notification. So parties to a proposed merger must tell us prior to closing the transaction if certain financial thresholds are exceeded. This is known as a notifiable transaction. So when a transaction is notifiable, the merging parties must advise us. They must also provide us certain information and then wait a specified period of time before closing the transaction, which is otherwise known as a waiting period. So parties that complete a notifiable transaction without supplying the required information may have committed a criminal offense, and they might be liable to a fine. And this is known as a failure to notify. Now, for proposed notifiable mergers, the amendments revise the Competition Act in a number of ways. I'll run through three of the most important changes. First, the Act has been amended to now include a so-called anti-avoidance provision. So anti-avoidance occurs when parties to a proposed merger intentionally structure the transaction to avoid notification, such that one or both of the financial thresholds are not met. So the Act now prohibits this conduct and explicitly states that in these types of situations, the merger notification provisions will apply, and so therefore, the proposed transaction is notifiable. Second, the amendments have clarified timing, including stating which days are holidays for the purpose of calculating waiting periods. So, for instance, Saturdays, Sundays, other publicly observed holidays are now explicitly listed as holidays. Third, the amendments have confirmed the business hours for notifiable transactions, including stating that information received after 5 p.m. Eastern Time will be considered as received on the next business day. Now, Anthony is going to quickly take us through some important changes to the Bureau's information gathering powers.
Great. Thanks, Majid. So during the course of our reviews, we rely heavily on information provided by market participants, including the persons who are the subject of our investigation, but also customers, competitors, and suppliers. In some cases, the information is obtained voluntarily, but in other cases, it is not. And we can request that a court issue orders to compel parties to provide the information we need. This can take place by way of examining witnesses, producing documents, and delivering written returns, which means providing us with written information or answers to questions. In order to make a production order, a judge must conclude that we have satisfied a two-part legal test under the Act. The amendments expand these evidence gathering powers in two different ways. Firstly, the amendments add a new power to compel written information from both foreign and domestic affiliates of a corporation. The circumstances in which such court orders can be obtained have also been expanded to include cases where the affiliate has or is likely to have records or information relevant to the inquiry. Previously, it was necessary to show that the affiliate has records that are relevant to the inquiry. Secondly, a court can now make an order to provide information against a person located outside Canada who carries on a business or sells products into Canada. This clarifies that orders to compel information can target a person situated outside of Canada. So here, the bottom line is the amendments expand the Bureau's court-ordered evidence gathering powers. So, Majid, I'm sure many people are interested in what are the next steps here. So you can walk through that.
Absolutely. So we're going to continue to work with stakeholders to implement the amendments in the most transparent and effective way possible. So as already mentioned, we have published a guide to the amendments on the Bureau's website. We've also updated our website in several other ways. We've added language that addresses changes to the law. For example, we've amended text regarding fines and AMPs for criminal and civil matters. We've also added disclaimer boxes where necessary to clarify that we're reviewing our enforcement guidelines and that we'll update them as needed. So our enforcement branches are currently examining what changes to the enforcement guidelines are required and what additional guidance we can provide. So we expect some public consultations will be launched in the coming months to engage with stakeholders on these changes. Now, aside from our actions, the federal government has committed publicly to broad consultations regarding further Competition Act reform. And as previously noted, ISED is responsible for the policy aspects of the Competition Act amendments, including consultations. So the Bureau will actively participate in the government's ongoing review of the Competition Act to further modernize and improve its operation. So I'll hand it back to Anthony now that the presentation portion of our session is complete.
Great. So let's now turn to addressing some of the questions that we've received in advance of this session through our registration portal and also more broadly. We really did receive a lot of great questions, and as I said earlier, we'll do our very best to address many of them, as well as others that may come up during the session. And I'll just point out, you can still use the Q&A function that you'll see towards the top of the MS Teams screen to send in questions. Some of the questions that we have received can be very specific and technical, great questions, but it may not be useful for us to try and address them today in a clear manner. We are hopeful that our forthcoming guidance will provide you with those necessary answers. For others, it's possible that a bureau representative may reach out directly to discuss your questions. We received many questions related to the Bureau's plan for further guidance based on these amendments. Not probably, hands down, more questions about this. What are our intentions than anything else? So I think it makes sense that we start there. So the fundamental question is, will the Bureau be publishing additional guidance documents? The answer is yes. We are certainly very aware of the importance to provide clarity and predictability for businesses and other stakeholders. And we're committed to doing the following. One is updating our existing guidance on drip pricing. Secondly, providing new standalone guidance on wage fixing and no poaching. And lastly, embarking upon significant revisions to the existing abuse of dominance guidelines. In terms of anticipated timing, which I'm sure many people would have as a follow-up question, for the new guidance on wage fixing and no poaching, as well as the revisions to the abuse of dominance guidelines, we expect to engage in public consultations in the late fall. Next, let's turn to some specific questions that we've received on wage fixing and no poaching.
So I'll handle those questions, and I'll start with the first one. So how does the Bureau intend to enforce the wage fixing and no poaching provision? Briefly put, we expect to rely on most, if not all, of the tools that we've used historically to enforce Part 6 of the Competition Act, which will include the wage fixing and no poaching provision once it's in force next year. So here are some examples of tools that we use to conduct our investigations. We look at information provided directly to us by complainants. We use our immunity and leniency programs, and those are described in detail on our website. We also conduct interviews with various parties, such as employees, employers, suppliers, customers, competitors, and other industry sources. We also rely on a variety of investigative methods to obtain information while we're on inquiry, including those provided in the Competition Act, as well as in the Criminal Code of Canada. So some examples of these methods include search warrants, production orders, and wiretaps. So another question we received about these provisions: how will the wage fixing and no poaching provisions interact with the ancillary restraints defense? So first, for those who aren't familiar with the ancillary restraints defense, or the ARD, as I'll refer to it, it's a defense contained in the Competition Act. And an ancillary restraint is an illegal agreement or term of an agreement that is directly related to and reasonably necessary for a broader and lawful agreement. And for more information about the ARD, you can consult our competitor collaboration guidelines, which are on our website. So the ARD, along with all relevant statutory and common law defenses, will apply to the wage fixing and no poaching offenses. So the next questions we received about these provisions are as follows. Will the wage fixing and no poaching provisions apply retroactively? Or will there be a grandfathering exception? So the short answer is no. There's no grandfathering exception contemplated, which is why these offenses will not come into force until 12 months after the rest of the amendments. So as mentioned before, the delay is to provide businesses with enough time to become compliant and to adjust their business practices. So to summarize, bottom line, as of June 23rd, 2023, all wage fixing and no poaching agreements that satisfy the elements of the offense will be prohibited in Canada, subject to all statutory and common law defenses. Now, the next question is a bit more specific. Can the Bureau confirm the application of the no poaching clause to arm's length commercial parties? So I can confirm that the no poaching provision will apply to arm's length commercial parties, subject again to all statutory and common law defenses. That said, we would need to consider, as always, the specific circumstances of a case at hand. Now, I should also mention that there are some specific considerations around certain business structures, including businesses involved in a dual distribution model and franchise agreements. And in the competitor collaboration guidelines that I mentioned, there are more details about these considerations. So we're exploring how this might extend to the new prohibitions. So the last set of questions that we received about no poaching and wage fixing. Is the no poaching provision intended to apply to the sale of a business? Or is its application limited to so-called two-way no poach agreements only? So the no poaching provision will apply to all agreements, whether they're one-way or two-way in nature, including in the context of a sale of a business. And the same is true for all relevant statutory and common law defenses, including the ancillary restraints defense. So let me give an example there. For instance, no poaching clauses that are directly related to and reasonably necessary for the sale of a business may not be a criminal offense by virtue of the ancillary restraints defense. As I mentioned before, in all cases, we have to consider the facts of each particular situation. So now I'll hand it over to Anthony to answer a few questions on a broader variety of topics.
Thank you, Majid. So next question that we received quite a few on is, how does the Bureau intend to enforce the drip pricing provision? So we expect our forthcoming approach to enforcement action against drip pricing to be very similar to that we previously used. As mentioned, the key effects of the amendments on drip pricing are that they confirm that the practice of drip pricing is false or misleading. As previously mentioned, we've successfully taken enforcement action against drip pricing through the use of the general false or misleading representation provisions of the Act. That said, we're working towards publishing new guidance or additional guidance to ensure clarity with respect to drip pricing. And I'll just point out, as part of the questions that we received, there were a number of specific fact scenarios regarding the potential application of drip pricing. And, in that respect, we've certainly taken note of these issues that will inform additional guidance that we would look to provide. Now, next, we had questions related to potential future amendments, not including here, including, does the Bureau anticipate changes to the efficiencies provision? And it's really not appropriate for me to speculate on potential future amendments that may occur. The efficiencies provision in Section 96 of the Act remains in force, and therefore we continue to apply it. However, anyone in the competition law world in Canada certainly knows that this is an area of significant debate, and the Bureau has said publicly that we think efficiencies should not be given primacy in merger review in Canada. I can also confirm, as Majid stated earlier, that the Competition Bureau will actively participate in the Government of Canada's ongoing review of the Competition Act. Another question that we've received a few times is what are network effects? What is meant by network effects? So network effects have been added to the list of factors to consider when assessing anti-competitive effects. They've been added as another example of barriers to entry in a market. So put briefly, generally speaking, network effects exist when the value or the benefit to a user of a product or service depends on the number of other users. So give a quick example. Consider one's use of a social media platform. The platform can become more valuable to you if your friends and maybe your family also use it. Yet another example of a network effect could be the use of a search engine. Again, the search engine is likely to be more valuable to the user when more people use it. In this context, more users means more data, which can be used to improve the search results. We'll now turn to Majid for the final question that we're going to cover from those that we received through the registration portal.
So we received a question about our interpretation of the new definition of anti-competitive act. So our view on this is twofold. First, the new definition of anti-competitive act, in our view, codifies certain types of anti-competitive conduct that are discussed in prior case law, but were not explicitly captured by the Competition Act. And second, the definition ensures that the abuse of dominance provisions are broad enough to capture conduct that harms competition or the competitive process, but not necessarily competitors themselves. So we're now going to take a look. We're going to take a second to see if there are questions from the audience that we've received live, and we will try to address some of those now.
Great. Thanks, Majid. So we do have quite a few questions that we've received live and in the previous days that we think are important to cover with the time that we have. So let me start with a bit of a logistical one, which is, will this recording be circulated to registrants? So yes, as was previously mentioned, this session is being recorded, and certainly our intention is to publish it on our website in due course. Because we're a government agency, we need to make sure that the session is accessible and fully translated as well. So that will take some time to make sure it's completed. And we have a French session tomorrow as well that we will also plan on publishing on our website in due course. Another question that we received is, what are non-price competition factors? So that was an issue that we talked about in the context of the amendments to the list of factors that are relevant. And I'm happy to walk through that one. So a lot of people, when they think about the benefits of competition, think about price, right? Companies compete for customers and they lower price to try and attract business. But non-price dimensions of competition are equally important. And we see that in companies trying to innovate and outdo one another, offering better quality, offering better service. Companies can compete on office hours, as an example. And so these are very important dimensions of competition that are relevant when we look at the effects of either a merger or business conduct or these types of practices. And in a similar vein to this, a question that we've received and have for a couple of years now, truth be told, is what role does competition play in consumer privacy? So why is consumer privacy relevant? And that's a really good question. And it's certainly one that people have been talking about, not just in Canada, but in the global competition community for the past couple of years. And generally speaking, competition can be relevant in a couple of ways. There's a couple of broad ways to look at it. One is just what I mentioned, is really that as a dimension of competition. So you can think about it as consumers and users care more and more about their privacy and what happens with their data. Companies are competing along this dimension, and by increasing privacy protections to their users or clients as well. So this can be what we just talked about, a non-price dimension of competition. So this can be relevant, in if we look at the effects of a merger or the effects of business conduct or a competitor collaboration. So that's how consumer privacy can be viewed as a non-price dimension in that respect. But also, if we look at our consumer protection work as well, or the consumer protection side, if there are misleading representations made to users or customers about how your data will be treated, and by making privacy representations that are not substantiated, then that can be conduct that runs afoul of our deceptive marketing provisions as well. So there's a couple of broad dimensions how consumer privacy can be relevant to our work. Maybe another question that we can take here. Sorry, I'm just looking through a list that we're working with in real time. What is the Bureau's reaction to the new drip pricing provision? Majid, do you want to tackle that one?
Sure, absolutely. So we welcome the fact that the drip pricing conduct that we've seen over the past several years and where we've taken action is now codified in the Competition Act. Ultimately, our actions in the past have been, as mentioned, under the existing false or misleading advertising provisions in the Competition Act. Our actions have been shown to be a sound application of the law. And now that we have a provision in the Act related to drip pricing explicitly, we feel that we'll be able to take action in the future on this conduct, using this provision going forward. We also believe that our guidance, the material we already have from our years of experience on this type of enforcement issue remains valid, is useful for businesses to understand their compliance obligations and to understand that element of the law. But we recognize that with a new provision in the Act, there is a need for guidance. And so, as we've said, we will update, we will take a look at the guidance we've provided, and we will make adjustments to that and additions to that as necessary. So in short, we welcome this change, and we feel that we will continue enforcing against drip pricing in the Canadian economy in the future.
Great. Majid, another question, maybe you can answer this one as well, relates to private access claims. So during the amendments discussion, we talked about how now private access claims can be filed in relation to abuse of dominance. So a question we received is who can file a private access claim? And it wasn't specific to abuse of dominance, but I imagine it's in relation to that amendment, but probably we can also answer it more broadly because there are existing provisions under the Competition Act where you can already file private access claims.
Sure, I'm happy to handle that. So, under the existing right of private access to the competition tribunal, any person that's directly affected by conduct can apply to the tribunal to bring a case. So what does that mean? The competition tribunal has discretion to determine whether a case can be brought by a private litigant or not. And so, as we mentioned, there's an existing legal standard for granting this right, this leave to make an application. And so the existing legal standard will continue to apply. Now, I should also mention that uh, that standard, the adjudication of that standard, is up to the competition tribunal. So we're not in a position to really opine on that. It's really up to the tribunal to make a call about individual applications for private access. So I would encourage you to look at the existing material that's publicly available related to the right of private access, and then to determine whether your organization, whether you would fall into that into that category. And I would encourage you to seek independent legal advice on that issue to determine, based on your facts, what your options are.
Great. Thank you, Majid. A logistical question that I just saw and I can quickly answer. And I guess this was in follow-up to when I was talking about the recording that we intend to publish in due course. Will the slides be circulated? I think right now our intention is that they would be included in the video that would be posted as well. And that would certainly be our intention. So the video would have the presentation embedded within it as well. I want to acknowledge we've received a couple in real time, and we did receive quite a few of these through our portal and otherwise, really specific questions about the application of the provisions to fact scenarios, even if they appear generally about what would happen in this situation. And they are very good questions, and I think we certainly appreciate that people are thinking long and hard about the amendments and how to ensure compliance with the law. During these sessions, our intention is not to cover these types of specific situations because, as I hope people can appreciate, the facts matter. And it's very hard to address a question about a hypothetical without digging a bit deeper and having follow-up questions. So it's difficult for us to engage in that in real time right now. What I can tell you is that all these specific questions, we take note of them and understanding what guidance is going to be helpful for the marketplace out there. So I just wanted to acknowledge that because we've received to various degrees some excellent but very specific fact scenarios. And of course, as we mentioned right off the bat, this session is not meant to provide legal advice on given situations too. A couple of other questions. Do the changes to the Competition Act make the application fairer? And I'm happy to take this one. The notion of fairness is it's certainly an interesting one under the Competition Act. What I would say here is that by and large, competition enforcement is about making sure that the market works and that companies are competing on the merits. So what we mean by that is that companies that are more competitive, that offer a superior product, better prices, should be rewarded in the marketplace. So that ensures that the market is working. And to the extent that the Competition Bureau is better able to investigate and address issues where you have a dominant firm abusing its position or an anti-competitive merger or a deceptive marketing that is fundamentally not only harmful to consumers, but also harmful to competitors who are playing by the rules and making legitimate representations, legitimate marketing. To that extent, the Competition Act is more effective as a result of these changes, in our view. So that is important, and certainly from our perspective, with a view to a broader consultation on the Competition Act, we try and bring that perspective of the enforcement perspective on what we're seeing and what would make it more effective so that competition works for Canadians, works for consumers, and ensures that business performance is fully rewarded and that the market is working, because that is, the can be the backbone of our economic growth going forward. I'm just looking at a couple of more questions. Majid, are damages awarded for private access? And I guess this is meant for the civil provisions.
Right. So under the civil provisions, damages are not awarded for private access. Private access is meant for private parties that are facing potentially anti-competitive conduct to seek relief from the tribunal in other ways that are outlined in the Competition Act. So that's the short answer, I think, to that question.
Great. Okay. I see we have about 2 minutes left, and I think we weren't able to get to all of the questions, but what we tried to do is cover the ones that we thought were going to be the most helpful for a broad audience, given the nature of the interest that we received in certain areas. Majid, just before signing off, I think that you wanted to make a couple of points about compliance more broadly, rightfully as our Director of Compliance.
No, absolutely. I want to touch on that for a second before we end. So with these changes to the Competition Act, many businesses will have to adjust their operations, their processes. They'll have to take a look at how they operate. And, for example, there may be staff now who need to be trained up on Competition Act issues. HR personnel, for example, should know about the wage fixing and no poaching provisions. And so all of this takes time and effort. So I'd encourage everyone listening in who deals with compliance directly or indirectly to really think about the implications of these amendments for your business and for your compliance program. For example, this might be a good time to do a regular risk assessment and keep the amendments that we've talked about today in mind when doing so. For those of you who don't have a competition law compliance program in place, you might have other programs or none at all. I would really encourage you to put one in place for your business, regardless of the size and of your resources. It doesn't necessarily have to take a lot of money or time, but you want to make sure that you understand your risks and you take actions effectively to mitigate them. Now, we've got public guidance on compliance programs on our website, and I should mention that we are actually in the process of revising this guidance. Now, we intend to consult widely on the changes, so I'd encourage all of you to sign up for the Bureau's mailing list, follow us on social media to hear more about that consultation. And we would love to hear your views on the proposed new guidance materials. So to close the session, Anthony and I would simply like to thank everyone for taking the time out of your busy schedules to participate. And we hope this was informative and useful for you. So with that, we'd like to just say have a great rest of your day.
Thank you. Bye-bye.
Bye now.